Hello everyone, welcome to EduTap. I am Arshdeep Kaur and today we will be starting with a different act, that is the Indian Contract Act 1872. We will be discussing the important provisions of this act that are important from the point of view of your examination, and we will be discussing in the form of important MCQs. Please pay attention, this is going to be very important for your examination. So let's start. Before I begin, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. In this, you will get chapter-wise tests, sectional tests and full-length tests. For your revision, this is going to be very helpful. Also, EduTap has come up with live crash course for both the phases, phase 1 and phase 2. It will include the live courses, it will also include the test series I have just mentioned, and it will also include one-on-one mentor support. So this is going to be very helpful for you. We are running a limited time period offer, so if anyone who has not enrolled yet can refer to the link in the description below. So let's start with the Contract Act. Let's begin. Question number 1. The codified law for the law of contract in India is it Indian Contract Act 1872, Indian Contract Act 1973, 1992, 1901, 1947? The answer is Indian Contract Act 1872, right? So the codified law for the contracts which regulate the provisions of the contract, it is the Indian Contract Act 1872. The Indian Contract 1872 prescribes the law regulating the contracts in India and is the key act regulating Indian contract laws. The law is based on the principles of English common law. Since the act was formed in the British India, it is mainly based on the principles of English common law. It was enacted on 25th April 1872. This is going to be important. It was enacted on 25th of April 1872 and it commenced. That means it came into force on 1st September 1872, right? So both of these dates are important. Enacted on 25th April 1872 but commenced, that is, came into force on 1st September 1872. Question number 2. The juristic concept of contract consists of free consent and capacity, offer and acceptance, consideration and undue influence, free consent and obligation. The answer is offer and acceptance. The juristic concept of contract consists of offer and acceptance. When an offer is accepted, it becomes a promise. Answer is option B, offer and acceptance. In every contract, an offerer makes an offer to enter into a contract with an offeree. The offerer offers to do something in particular or to refrain from doing something in particular, and if the offeree accepts this offer, a contract is created. The word offer has the same meaning as proposal, but you must know that in Indian Contract Act, the word offer is not used. The word which is used is proposal. We used the word offer because it is applicable in the English law, and since that we have derived it from the English law itself, so the word offer is not wrong, but in Indian Contract Act, the word only that is used is proposal, right? So if a proposal is made by a person and the other person accepts it as it is, then a contract is made, right? So it deals with the offer and acceptance. As you can see, both offer and acceptance must meet certain conditions, right? So when an offer is accepted, it becomes a promise, right? Question number 3. The law of contract essentially determines in which a contract is a tort and crime. A promise may not be made, a promise be made, a promise shall be legally binding on the promiser, and none of the above. So the answer is a promise shall be legally binding on the promiser, right? That is why the Contract Act exists. The law of contract is the branch of law which determines the circumstances in which a promise shall be legally binding on the person making it. So who is making the promise, he has to bind by it. This is what the contract law is all about, right? Question number 4. A proposal when accepted becomes, I've told you this in question number 2. So a proposal when accepted, it becomes a promise, right? Let's read it. When a person, before understanding what promise is, we must know what proposal is. What is the definition of proposal? So let's read it first. When one person signifies to another his willingness to do or abstain from doing anything. So when one person, he signifies means he conveys He conveys his willingness to do what? From doing a thing or from abstaining to do a thing, right? So when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent, with a view to obtaining his assent, is that it is his intention that it is his intention to get his assent, right? So it is his intention, it is this intention of that other is important, right? So if you are making an offer to one person, that other person, you need the assent of that other person only, right? So that other person to such act or abstinence, he is said to make a proposal. So proposal basically is like, for example, A offers to B that I want to sell my watch for 5,000 rupees. Do you want to buy it? This is an offer. This is a proposal. Now, if C was also standing there, right? If C was also standing there and C says that, okay, I will buy your watch, but I will buy it for 2,000 rupees, for example. So is this formation of a promise? No, it's not, because that person is important. Now, if C is offering something to A, that is going to be a different offer, and then if A accepts it, then it's going to turn into a promise, right? In this scenario, because it is written that other, only that other person is important. If B agrees to it, then a promise is made, right? Now, what is accepted? What is the definition of accepted? When the person to whom the proposal has been made, to the person to whom the proposal is made, only to that person, signifies his assent. Here in this example which I have told you, if here B says, okay, I am ready to buy a watch for 5,000 rupees, then in that case he has accepted the offer and the promise is made, right? So when the person to whom the proposal has been made signifies his assent thereto, the offer is said to be accepted. A proposal, when accepted, becomes a promise, right? And when that such a proposal is accepted, it is absolutely accepted by the promisee, it becomes a promise. It is accepted by B, then it becomes a promise, right? Question number 5. A patient in a lunatic asylum who is at intervals of sound mind may not contract, may contract during those intervals when he is of sound mind, may contract only after he becomes completely of sound mind. The answer is option C, may contract during those intervals when he is of sound mind. So the principle basically is that when a person is contracting, he should be of sound mind. He should be of sound mind to such extent that he is able to judge the circumstances and the consequences. If he is of sound mind during those intervals, during the time when he was forming the contract, then it is going to be a valid contract, right? Let's read it. A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it. So the criteria is if during that time, if at the time when he makes it, right? So if at the time when he makes it, he is capable of understanding it, he is capable of understanding the contract. The first and the foremost is he is capable of understanding the contract and for forming a rational judgment as to the effect upon his interest. First, that he is capable of understanding it, and second, that he is forming a rational judgment, and he is also capable of forming a rational judgment as to the effects of the contract on his interests, right? So this is what section 12 talks about. A person who usually is of sound mind. So a person who usually is of sound mind is that usually he is of sound mind, but occasionally he is of unsound mind, right? So a person who is usually of sound mind but occasionally of unsound mind, kabhi kabhi he is of unsound mind, may make a contract when he is of sound mind. So he can make contract when he is of sound mind. Person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. So the crux is that a person can enter into a contract when he is of sound mind. And what is sound mind? When he has the capacity to understand that what is written in the contract and also to have a rational judgment about its effect. That's all, right? Question number 6. An agreement without consideration will be. So as a general rule, any agreement without consideration is void. Consideration has to be by both the parties. Consideration means something of a value, right? Something that is of any value, right? So any agreement without a consideration, it is void as a general principle. So the answer is option B. A contract without consideration is void because it is not legally enforceable. Consideration means that each party must provide something of value, right? Something of value to the other party as designated by the contract terms. So in the example we have taken, A tells B that I want to sell my watch. Will you be ready to buy it for 5,000 rupees, for example? If B agrees, then B is going to give 5,000 rupees. That is going to be the consideration, and A will give his watch to B. That is going to be the consideration, right? So the consideration has to be from both sides. So if there is consideration from both sides, then it is valid. But if it is missing consideration, if there is no consideration in the contract, then it is a void contract. It has some exceptions that we will be talking later on, but as a general principle, an agreement without consideration, it is void. Question number 7. A void agreement means. What is a void agreement? Agreement not enforceable by law. Agreement illegal in nature. Agreement not acceptable to the court of law, except agreement violating legal procedure, or none. It is agreement not enforceable by law. So any agreement which is not enforceable by law, it is void. It is given in section 2G. A void agreement has no legal effect. It has no legal effect, and agreement not enforceable by law is said to be void. Void means that it will have no legal effect. An agreement which does not satisfy the essential elements of the contract is void. So the essential elements, they have been given in section 10. If the contract is not in accordance with section 10, then it is a void contract. Void contract confers no rights on any person and creates no obligation. So no rights are created, no obligations are created on any person in case of a void contract. So void contracts, they are defined in section 2G of this act. Question number 8. A contract will still be a valid contract if it is opposed to public policy, is restraint of trade, is restraint of marriage, without adequate consideration, in restraint of commerce. The answer is without adequate consideration, that is option D. So the amount of consideration that is immaterial to enter into a contract, right? If, for example, if A sells his house for 500 rupees to B, this is going to be a valid contract, no matter if the consideration is inadequate or adequate, right? For this, we must read section 25, and section 25 deals with some exceptions where the consideration, if a contract is without consideration, then also in that case it is valid. So it deals with 3 such circumstances, 3 such situations. We will be dealing with that. So let's start. First, agreement without consideration, void. An agreement made without consideration is void. This we have already done, that it is a general principle of contract that if there is no consideration in the contract, then it is going to be a void contract, right? First exception, but there are 3 exceptions, and the first one we are going to read it now. It is expressed in writing and registered under the law for the time being in force for the registration of documents, and is made on account of natural love and affection between the parties standing in a near relation to each other. So the first exception talks about that such a contract is in writing and it is registered. The first exception has 4 basic conditions. First, it is in writing. Second, it is registered. Third, it is made out of love and affection. And fourth, it is made between the parties who are in close relation to each other. Right? So if any such contract is made without consideration, then it is going to be a valid contract. For example, we say like A is the mother and B is the son. A promises B that I will gift you this house, right? And she writes it, she gets it registered, and everything is done, right? So all the 4 things, all the 4 conditions, all the 4 criteria, they are met with, right? First, it is in writing. Second, it is registered. Third, it is out of love and affection. And fourth, they are in a close relation to each other. So then it is going to be a valid contract. And now if A refuses to give his house to B, then B has the right to move to the court, right? This term used parties standing in a real This term used parties standing in a near relation. It only includes relations such as husband and wife, mother and daughter, mother and son, siblings, only such. Best friend, a friend, such relations do not come under this standing in near relations. Like, you may have love for your best friend, but you are not in a relation with your best friend, right? So this does not come within the meaning of this section, and for this purpose we also have to read explanation 1. Let's move to explanation 1 first. Nothing in this section shall affect the validity as between the donor and donee of any gift actually made. By this explanation we know that it does not mean that we cannot gift someone anything we are not in close relation with. Like, you have the right, you can gift your house to your friend if you want, right? But that will come under gift, and that gift that is covered by TPA. Okay, there the provisions of gift are given in the TPA but not in Indian Contract Act. So in case of Indian Contract Act, the 4 conditions so in case of Indian Contract Act, gift is not covered, it is covered in TPA, right? So the first one, as I've read, let's read it again. Now you will understand it better. It is expressed in writing. First of all, it is in writing and registered under the law for the time being in force for the registration of the documents, and is made on account of natural love and affection between parties standing in a near relation to each other. So if all these 4 conditions are met, it is a valid contract even though it is without a consideration. Second one is, it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do, right? So what does this mean? It is that this promise has been made to compensate wholly or in part for something which the promisee has voluntarily done, or has done something because the promisor was legally bound to. And let's understand this with an example, right? Supposingly that A has a house in India but he was in UK, and B is a neighbor of A, right? A's house was set on fire. On a particular day, A's house was set on fire. So B saw this. B saves A's house. He calls for the fire brigade and he saves it in any way possible. So he basically saves it. So when A returns, he gets to know about this. He comes to know about this, and what he does is he promises B that I am going to compensate for everything. I am going to compensate wholly for whatever price you paid to the fire brigade, or whatever your expense was. I am going to compensate it. Supposingly it was 5,000 rupees. So he says that I am going to compensate you 5,000 rupees. So this is a valid contract, even though the consideration is only from one side, that A is paying 5,000 rupees for an act he voluntarily done. He has done voluntarily, right? So this is going to be a valid contract even though the consideration is from one side only. And now if A breaches this contract, B has the right to move to the court. He has the legal remedy to move to the court, right? The second one talks about legally compellable. Legally compellable, for example, you say that A was supposed, in the same circumstances, for A was supposed to pay his rent to his landlord, for example C, right? But A did not pay and he is in UK right now. And if B pays his rent, right? If B pays his rent, then he has done something A was legally bound to do, right? He was legally bound to do, but B has done it. And here also, if A promises that I am going to pay you back, I am going to compensate you wholly or in part, then this is a valid contract even though the consideration is only from one side, right? Now the word is compensate. For example, we were talking 5,000 rupees. The word is compensate here. If he says I'm going to pay you 10,000 rupees, this is not covered here, right? It is only the compensate. Only compensate to that amount which was his, right? Compensate wholly or in part. So if he compensates, if he says I am going to pay you 10,000 rupees, I am going to pay you more, then it is not covered under this section. Third is, if it is promise made in writing and signed by the person to be charged or by his agent generally or specifically authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law for the limitation of suits. So this relates to the time barred debt. I hope everybody knows what time barred debt is. time barred debts, for example, means that A lends money to B and B says I am going to pay you back in 1 year, right? After 1 year, B does not pay to A. Now A has a legal remedy. A can move to the court, but there is a period of limitation, right? Supposingly the period of limitation is 3 years. So A within these 3 years has a right that he can move to the court against B. But A does not exercise his right, and what happens is that his debt becomes time barred. That is, the court, now he cannot move to the court to claim that debt. So this is what is a time barred debt. Now he cannot move to the court under this situation, right? But you must remember that his right is still there. His remedy is exhausted, that he cannot move to the court, but his right is still intact. It does not mean if he cannot move to the court, it does not mean that he cannot ask for that payment from A, right? So if after the time has barred, after the limitation period has gone, if B promises that okay, I am going to pay you this much amount, so this is valid. Under this exception, this is valid. In case of a time barred debt, it is going to be a valid contract, right? So if again B is not paying him, now also then A has a legal remedy to it, right? So now let's read it again. It is a promise made in writing and signed by. It must be in writing, but the conditions are it must be in writing and signed by. Signed by either B only or by his agent, generally or specifically any person authorized, right? To pay wholly or in part a debt of which the creditor might have enforced payment. एक ऐसा creditor डेट ऑफ विच द क्रेडिटर माइट हैव इन्फोर्स्ड पेमेंट, ही माइट हैव इन्फोर्स्ड इट अगर उसको लिमिटेशन लॉ ने ना रोका होता, राइट? सो डेट ऑफ विच द क्रेडिटर माइट हैव इन्फोर्स्ड पेमेंट बट फॉर द लॉ ऑफ लिमिटेशन ऑफ सूट्स, बट ही कैन नॉट डू दैट बिकॉज ऑफ द लॉ ऑफ लिमिटेशन. इट इज नोन एज टाइम बार्ड डेट, एंड ऑन द basis of time barred debt, if B again promises that okay, I am going to pay you, I will pay you wholly, then it becomes a valid contract, right? Explanation 2. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. This was our question. So if the consideration is inadequate, if A is selling his house for ₹5, then also it is a valid contract. It is valid consideration, right? So it says an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court. But that inadequacy, that can form a part of the evidence, right? It can be taken into account by the court in determining the question whether the consent of the promisor was freely given or not, whether the promisor had given the consent freely or not. For that purpose, that inadequacy of the consideration, that can be taken into account by the court of law. Right, I hope this section is clear to you. This was an important section, that is why I've mentioned the entire section in this explanation. So the contract will still be a valid contract if it is without adequate consideration. Question number 9. A took his wife B to England for vacations. Due to some business emergency, A had to go back to his place of work immediately while leaving B in England owing to her ill health. A promised to pay B £300 per week as maintenance during her stay in England, but failed to pay. If A is sued by B, then is it a valid contract? First of all, we have to find out that if this is a valid contract. The answer is A is not liable because of the lack of consideration on the part of B. I've told you that consideration has to be on the both sides, right? So A is not liable because of the lack of the consideration on the part of B. Let's read the explanation. It is a case. It was a case law. It is a 1919 case, Balfour versus Balfour. So we understand that a mere social agreement made within a family cannot be enforced in the court of law. These agreements do not hold any legal binding authority. And why is that? Because there must be an intention to create a legal relation. In the case I have just mentioned, there was no legal intention. There was no intention, right? There was no intention to create a legal relation. There was no intention to create a legal relation at the part of the parties. Owing to all this, Mr. Balfour could not be sued by Mrs. Balfour under in law of court. Right? Question number 10. To convert a promise To convert a proposal into a promise, the acceptance must be. So the criterias, what are the criterias, how the acceptance should be? What is it? It should be absolute and unqualified. What is absolute? Absolute means it should be accepted as it is. Like I gave you the example of that watch, right? If A says that I want to sell my watch, will you take it for 5,000 rupees? If B says yes, I'm gonna buy it for 5,000 rupees, then it is a valid absolute acceptance. But if B says no, okay, I will buy your watch but for 2,000 rupees, then it is not acceptance, right? It is again an offer. Now this becomes an offer, and now who has the right to accept it? Now A has the right to accept it. It becomes a new offer, right? So an acceptance, it should be absolute and unqualified. It should be as it is. It should be accepted as it is. Let's read it. Rules regarding valid acceptance. Acceptance can only be given to whom the offer was made. If there are three friends standing and A offers something to B but C accepts it, then also it is not a valid offer, right? So then also it is not a valid acceptance, right? So acceptance can only be given to whom the offer was made. It has to be absolute and unqualified. It has to be absolute. First of all, it has to be absolute and it has to be unqualified. This we have done. Acceptance must be communicated. It must reach to the person. It must be in the prescribed form. So it must be in prescribed form means it has prescribed some mode that it should be in this mode only, then that mode has to be followed, and it can be implied acceptance also be through the conduct also, right? It does not have to be in writing or orally also, but it can also be inferred from the conduct of that person as well, right? Let's move on. Next question. A contract caused by one of the parties to it being under a mistake as to the matter of fact is. So it is talking about a unilateral mistake, a mistake by one party, and this mistake is the mistake of fact, not the mistake of law. It is mistake of the fact. The answer is it is going to be still a valid contract. Let's read it. A contract is not voidable merely because it has caused by one of the parties to it being under a mistake as to the matter of fact. Example, A was under a misconception. He was mistaken about the product, about a certain thing about a product. So in that case, it does not become voidable at the option of A. Right? I'll give you an example. For example, A had to buy a flat, and he thought that he is well versed with the description of the flat. He knows the plan very well. He is well aware of everything. B gives him a plan. He shows it that this is the plan, please go through it, and if you have any difficulty, let me know. But A does not go through that plan because he is under the mistake that he knows everything about the flat. So he buys that flat. Now what happens is, after some time, what happens is that A comes to know that the garden, which was attached to the flat, is not a part of the flat. He is not the owner of that garden. And now when he checks the plan, he comes to know, and now because of this mistake on the part of A, the contract does not become voidable. He does not have the option that he cannot say it was he cannot say that this was a mistake and now I want to exercise my right and I want to make this voidable. This is going to be a valid contract even after A finds out that he was mistaken, right? So it is going to be a valid contract. Next, a mistake also as a matter of fact concerned to the contract. Therefore, a unilateral mistake does not affect the validity of the contract, right? And cannot be a ground for setting aside the contract in the court of law. So here the A cannot ask the court to set aside that contract. Question number 13. Which one of the following sections of the Indian Contract Act relates to the rule no consent, no agreement? So the answer here is option D, that is section 13, right? So section 13 defines that no more persons are said to consent when they agree upon the same thing and in the same sense. I've told you acceptance is unqualified, it is absolute, right? So this means that they have to agree upon the same thing and they have to agree it in the same sense. It has to be during the same time and it has to be in the same sense. Then only the consent, then only the acceptance is right, then only the consent is right, right? So two or more persons are said to consent when they agree upon the same thing in the same sense. Question number 14. who is competent to contract? Now the question arises that who has this power, who has this right to enter into a contract? So this is very important. So the answer is person who has been disqualified from contesting any election. Now, question for achievers, you have to comment the right answer below. The question is, A sells by auction to B a horse which A knows to be of unsound mind. A says nothing to B about the horse unsoundness. A does. Has he committed fraud? No fraud, misrepresentation, undue influence, or none of the above? So you have to comment the right answer below. So that was all for today. We have done one video on the Contract Act, and all these provisions are really important from the examination point of view. I hope this was a helpful session for you. For more such videos, please subscribe to the channel EduTap. Thank you.